Here.
Commissioner Carruthers,
Here.
Commissioner Solomon,
Present.
Commissioner Williams,
Here.
and the chair is here. So we do have a quorum. Next, we will move to approval of the agenda. I assume everybody's looked at it, and I would entertain a motion in a second.
So moved.
Second.
Thank you. Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
Yes.
and chair votes yes, the agenda is approved. Next, we go to the approval of the minutes of our last meeting, which was held on February 5th of this year. And is there a motion in a second to approve said minutes?
Motion to approve.
Second.
Thank you. It's been moved and seconded. Any discussion? Hearing none. Commissioner Bluestone or Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams.
Yes.
Chair votes yes. The minutes of the February 5th meeting are approved. Okay, on to item number 4, which is outcomes from the 2021 legislative session. Jeremy, I'll turn it over to you.
Thank you, Chair. Commissioners, I don't intend to go through every bill that's proposed to amend one of the statutes that the Ethics Commission has jurisdiction for, or in some way relates to the Ethics Commission. But I do want to provide you with a brief set of outcomes from the legislative session, bills that the legislature had passed and are now awaiting the governor's approval or veto. Although I think the latter is unlikely with respect to any of these bills, apart from certain line item vetoes on HB2. But I'm going to go through five bills that the legislature passed that in some way affect the State Ethics Commission. The first is HB2, the General Appropriations Act. The legislature appropriated just over $900,000 to the State Ethics Commission for FY22. $623,000 is for the 200s FTE that provides for 5 FTE in FY22. And a little bit more on top of that to cover our 6th Special Projects Coordinator 2 position for a few pay periods in the beginning of FY22. The contracts and other operating expense appropriations, the 300s and 400s budget category, were flat, so $175,000 for contracts, $102,000 for other operating costs. HB2 also included an appropriation to increase all classified and exempt salaries by 1.5%. And from that appropriation, Wendy estimates that the commission will receive approximately $8,000 in additional appropriations to cover that 1.5 cost of living salary increase. So that's the main highlights from HB2. There were no special or supplemental appropriations in HB2 this year for the commission, and nor did the commission seek any. Next, HB 244 was the bill that the State Ethics Commission and the Secretary of State worked on for months in the interim in anticipation of the legislative session. It passed the legislature. What that bill does is 4 main things with respect to the State Ethics Commission. First, it excises the notarization requirement for administrative complaints that are filed with the Ethics Commission. So there's no longer a notarization requirement for administrative complaints. Second, that bill amends the Financial Disclosure Act to require that the 7 of you have to file financial disclosures in the next year. The commission has voluntarily filed, or each commissioner has voluntarily filed financial disclosure forms in 2021, but starting in 2022, each of the commissioners will be required to file financial disclosure forms. Third, the HB 244 clarifies the venue provision in the State Ethics Commission Act that applies when the State Ethics Commission files civil enforcement actions in state district court. And the venue provision clarifies that the proper venue for civil actions or the State Ethics Commission files to enforce one of the statutes it has authority for has to be filed in the district court where the defendant resides. And that's at section 9F of the State Ethics Commission Act. And then last, in the big project of HB 244 was to delineate the administration and enforcement roles between the State Ethics Commission and the Secretary of State's office for the Campaign Reporting Act, the Financial Disclosure Act, the Lobbyist Regulation Act, and the Voter Action Act. And that delineation has a number of details that the commission has reviewed in the past, and I won't go over now, but HB 244 passed with very little in the way of turbulence in any House or Senate committee or on the floors of either body. So those are the two bills that the commission was involved in the interim and was expecting. There are other bills that the commission maybe necessarily wasn't expecting, but which created statutes or amended statutes that affect the State Ethics Commission. The first is Senate Bill 75. So Senate Bill 75 creates the Non-Disclosure of Personal Sensitive Information Act. So this will be a new statute in Article 10. This legislation defines what sensitive personal information is. It prohibits state employees from disclosing sensitive personal information, except in a few enumerated instances. It provides for penalties. It provides the State Ethics Commission the authority to file civil enforcement actions to remedy violations of the Sensitive Personal Information Act, the Non-Disclosure of Sensitive Personal Information Act. And it also amends the State Ethics Commission Act's provision in Section 9A that lists the subject matter jurisdiction for administrative complaints that the commission can adjudicate in its quasi-judicial capacity. So the bill amends Section 9A of the State Ethics Commission Act to add the Non-Disclosure of Personal Sensitive Information Act to the list of statutes for which the commission can receive administrative complaints, investigate those complaints, and adjudicate those complaints. Next is Senate Bill 12. Senate Bill 12 creates the revised uniform law on notarial acts, so notaries public, the statute that governs and regulates notaries public and other notarial officers that can perform notarial acts. This is a large bill. It defines who is able to perform notarial acts. It regulates how notarial acts may be performed and certified and recorded. It governs how the Secretary of State's office can issue commissions to notaries public. And interestingly, sections 22 and 33 of this bill, SB 12, implicate the State Ethics Commission. So section 22 of the bill empowers the State Ethics Commission to deny or revoke or suspend a notary public's commission for an enumerated list of violations that somehow relate to dishonesty, to put it briefly. So the bill enables the Secretary of State's office to have some control, the State Ethics Commission, in conjunction with the Secretary of State's office, to have some control over the revocation or the denial of a commission for a notary public. This bill also adds the uniform law on notarial acts also to the list of statutes for which the State Ethics Commission can receive administrative complaints, investigate said complaints, and adjudicate said complaints. So this bill also amends Section 9A of the State Ethics Commission Act to add this revised uniform law on notarial acts to the list of statutes that the State Ethics Commission can adjudicate. It's a bit unusual, I have to say. I think it's somewhat outside of the paradigm of what state ethics commissions normally do. But as the legislature told me, that the legislature makes the rules for everybody else, and they did so here. So this bill will take effect on January 1st, 2022. So the commission has some time to prepare and think about the ways in which it might work with the Secretary of State's office with respect to the revised uniform law on notarial acts. And so, Chair, the fifth bill is the Redistricting Act, and I prefer to kind of discuss that in the next agenda item. But I'm happy to entertain any questions that to my ability that commissioners might have on these bills.
Thank you. Commissioner Becker, do you have anything on these four?
No, sir.
Thank you. Commissioner Bluestone?
Not on those four, but I'm curious what happened with the bill that was going to have the Constitution amended to have the commission, the Ethics Commission, set salaries for legislators and others. Could you just fill us in on that or any other related salary bill that went forward?
Sure. So Chair and Commissioner Bluestone, that Senate joint resolution passed the Senate Rules Committee and never received a hearing in the Senate Judiciary Committee. So it was one of the pieces of legislation that stopped without ever receiving a hearing in Senate Judiciary. So that bill actually made it, that joint resolution made it less far through the process this legislative session than it did in the previous regular legislative session.
Thank you. And I assume there was no other bill, because wasn't there another proposal to have a separate commission set up to provide salaries? And did that not pass either?
So Chair and Commissioner Bluestone, there was a House joint resolution that passed the House and went over to the Senate and toward the end of the legislative session. That House joint resolution was amended in the Senate Rules Committee to basically replicate the Senate joint resolution to provide for, instead of an independent commission to set salaries, which was in the House joint resolution, it was amended to provide that the State Ethics Commission would have that salary setting power in the Senate Rules Committee. So what the House passed was amended in Senate rules to make it the same as the Senate joint resolution that would have given the Ethics Commission the power to set the salaries of state elected officers. But that House joint resolution also did not make it for a hearing in the Senate Judiciary Committee.
Thank
Can I
you.
ask a question?
Sure.
What are the rules for whether a bill receives a hearing?
Gary's
There ain't
laughing.
no stinking rules.
So
That's it.
We're all laughing.
Chair and Commissioner Baker, my experience of legislative committees is that the committee chair has a great deal of influence as to whether or not a bill will receive a hearing in practice. If there's a particular Senate or House rule that provides more de jure kind of clarification, I don't know it, but I think that the de facto practice is that the committee chair has an enormous ability to decide what bills get a hearing and what bills do not.
Thank you.
You might
Thank
say
you.
that's even more than enormous.
It's absolute. Yes. Commissioner Carruthers, any questions?
I'd like to know who and what inspired the notary provision.
Yeah, really.
So, Chair and Commissioner Carruthers, that bill was sponsored by Senator Ivy Soto and Representative Baldonado. I believe prior to this legislation, the Regulation and Licensing Department played a role in the adjudication of alleged violations of the notary law by notary publics, by notaries public. I don't believe there were many complaints yearly that RLD kind of received and adjudicated. Although I don't know how many and haven't spoken with the RLD superintendent about that volume of complaints. I think the story of how this legislation kind of sat this set of duties with the Ethics Commission in the last instance was the Secretary of State's office in a prior draft of this bill kind of had this set of duties to investigate, adjudicate alleged violations of the notary's public law. And consistent with the theme of that office that they want to be out of the business of doing investigations, I believe that there was pressure from their office to put this with the State Ethics Commission, which has a kind of ability to do investigations and to adjudicate complaints, given our rules of procedure, our proceedings portal, the commission subpoena authority. So I think that that's the arc of how these provisions finally ended up in SB 12. My hope is that instead of voicing a lot of complaints about this being outside of the normal purview of a state ethics commission, my hope is that it will supply an argument for the commission to receive more funding in future legislative sessions. I hope that it signals to Senator Munoz and the LFC that the State Ethics Commission in the 2021 regular session received even more responsibilities to adjudicate and oversee and enforce certain statutes, while at the same time receiving a 5% budget decrease from FY20. And my hope is that this will be a good faith and sound argument for the commission to receive more in the way of resources that I believe the commission will very much need in the years to come.
Good, thank you.
Commissioner Solomon? Commissioner Solomon, you're
No further questions. Thank you.
thank you. Commissioner Williams?
Yes, I have some questions. As you commented on, it appears to me that there seems to be a great increase in our workload. And having said that, I do wonder if you will be able to have more personnel to handle this additional workload. And when could you ask for additional personnel? At what point in time, if the workload is too much for us to carry it? So
Chair and Commissioner Williams, I might ask Wendy to help supplement the answer here, but in October of this year, 2021, we'll go before the LFC and ask for a budget increase for FY23. To get through FY 2022, if we really find that the work is overwhelming the resources of the commission staff, it's possible that we could ask for a supplemental appropriation in the next legislative session to help with FY 22. The commission still has a decently healthy contracts budget. There was no decreases to the commission's contracts budget for FY 22. And if we find ourselves overwhelmed by the work in FY 22, just what the attorney staff could handle in the way of adjudicating administrative complaints, which is not a discretionary responsibility, it's something that we have to do. then we might be able to use some of that contracts money for additional attorney contractors. So that's some brief responses. And Wendy, if you want to add anything by way of how we might handle FY22.
Yes, thank you, Chair and Commissioner Williams. We can definitely contract out and use funds from the 300s and possibly from our contracts and our other expenses fund to take care of employees. And then in October, if we need to, we can go for a supplemental, as Jeremy stated.
Thank you. Well, I am concerned because I see an increase, a big increase in our advisory opinions and what we're being asked to do. So with this additional workload, I am concerned that this organization can carry this on. And but thank you for I have one more question. Thank you, Wendy. On the notaries, you indicated that, Jeremy, that we would receive complaints if there was anything wrong with one of the notarians and so forth. How would we receive that complaint? Would that be filed by the Secretary of State, or how will that work?
So Chair and Commissioner Williams, under the State Ethics Commission Act, any person can file a complaint alleging a violation of one of the statutes within the commission's jurisdiction. So a complaint alleging that there was a violation of the statute governing notaries public could be filed by any person.
Okay, thank you. I have no other questions.
Thank you. Chair has no questions. Thanks, Jeremy. If you want to move on to the redistricting committee and the bill in the next item on the agenda.
Thanks, Chair. I'm happy to do so. So the purpose of this agenda item is to orient the commissioners to Senate Bill 304, which at the very end of the legislative session created the Redistricting Act. And the Redistricting Act creates what the Act refers to as a Citizens Redistricting Committee. Under the Redistricting Act, the State Ethics Commission has a very important appointment responsibility to appoint 3 members to that redistricting committee. And so I want to orient you to that responsibility. And then on this agenda item, there is an action required. And the hope is that the commissioners will now approve a selection procedure and method to make these appointments to the Citizens Redistricting Committee. And what I'll propose after the introductory remarks is that the commission adopt a procedure that's similar to how the 4 initial legislatively appointed commissioners reviewed and selected the appointments that resulted in Commissioner Baker and Commissioner Solomon's appointments in 2019. So first, the Redistricting Act creates a Citizens Redistricting Committee. That committee, under the statute, has a set of responsibilities to hold a series of open meetings to receive input regarding the creation of proposed redistricting plans for the New Mexico Senate, the New Mexico House of Representatives, New Mexico's congressional delegation, and the New Mexico's Public Education Commission, which are the 4 entities that currently require or will require redistricting in the upcoming redistricting. So to propose a set of maps for each of those districts after receiving public input upon several meetings and creating those maps subject to certain statutorily defined criteria regarding what the Citizens Redistricting Committee must consider, must not consider, what legal requirements they have to comply with when drawing the maps which issue from the Equal Protection Clause of the federal Constitution, the Voting Rights Act, et cetera. So basically, there's a legal framework by which this committee has to receive input and draw the maps. The committee will propose those maps to the legislature, and in the final version of the bill that passed, the legislature has the discretion to use the maps, amend the maps, or completely ignore the maps and go forward with its own redistricting. In the Senate junior bill, in the junior appropriations bill, there was an appropriation of $300,000 to the redistricting committee. So they do have some money to work with. The redistricting committee it's comprised of seven members, four of whom are appointed by legislative leadership, and 3 of whom are appointed by the State Ethics Commission. Like the State Ethics Commission, the Citizens Redistricting Committee has limits on how many Democrats or Republicans could be on the committee. So and the way some of those limits are practically enforced is with respect to the State Ethics Commission's appointments. So the State Ethics Commission is responsible for appointing three members. 2 of those members cannot be affiliated or registered with either the Democratic or the Republican Party. So they have to either be minor party members or independent / decline to state voters in New Mexico. The State Ethics Commission, in addition to appointing those 2 members of the Citizens Redistricting Committee, also appoints the chair. The chair has to be a retired New Mexico Court of Appeals judge or a retired New Mexico Supreme Court justice. And so the State Ethics Commission has the responsibility of making those 3 appointments. In the materials that you have for this meeting, I proposed a timeline by which the commission could solicit applications for and receive the applications and conduct interviews and make a selection. So roughly that timeline is as follows. Today, the commission will adopt the selection process for appointments. On the day that the governor signs Senate Bill 304, assuming that she will sign it, the application period will open. At that point, we've created an online application form to receive applications, and we'll do everything in our power to push out the application form throughout New Mexico, using our website, using Twitter, with the assistance of several nonprofit and citizens groups that are very concerned about redistricting. We'll also try to circulate the commission's appointment responsibility and the application process in editorials and newspapers around New Mexico. And so we're hoping to begin that on the day that the governor would sign Senate Bill 304. On May 21st, the application period would close. On May 26th, I would provide the 7 state ethics commissioners a short list of approximately 8 persons who are the best able applicants for the 2 non-major party positions, and also provide the commissioners a list of every retired Court of Appeals judge or retired Supreme Court justice that applied. So you would get that on May the 26th. On May the 31st, under the Open Meetings Act, the State Ethics Commission's agenda would be available for the public. And so the public would see those applicants that are selected for interviews. On June the 4th, the next State Ethics Commission meeting, the commission would conduct interviews of the applicants and make a selection that day. And on July the 1st, the day that the redistricting act becomes effective, the general counsel would administer the oath of office to the 3 appointees that the State Ethics Commission selects. So that's the rough proposed timeline for making the appointments. And the selection process that I propose that the commission engage in on June the 4th after conducting the interviews is that each commissioner will complete a preference ranking from first most preferred to 7th or 8th least preferred of the applicants for the non-major party positions. And I would anticipate that the commissioners would conduct the interviews in the morning. And when the commissioners are finished with their interviews, much like how we did this in 2019, the commissioners would email me, provide me with the preference ranking. I'll aggregate the preference rankings. The two members or the 2 applicants that have the lowest overall score would be selected. And in the case of a tie, if there was a tie for the second and the third most preferred applicants, or if there was a 3-way tie for first choice, the tie-breaking rule that I propose is that the preferences of Commissioner Baker control. Commissioner Baker being the only independent member of the State Ethics Commission. And that selection process kind of is in detail with examples kind of spelled out in the meeting materials. And with that, Chair, that's my brief introduction to the Citizens Redistricting Committee, the State Ethics Commission's role, and the process and timeline which I propose the commission do its work.
Thank you, Jeremy, and thank you for providing it to us ahead of time in your emails. So, as is typical, we will start with Commissioner Baker for a round of questions, and this may involve more than one round, but go ahead. Jeff, do you have anything? Are you still with us, Jeff?
I've been hitting the unmute button
There
for,
you are. Okay, I'm sorry, there you are.
it's all right. No questions.
Thank you. Commissioner Bluestone?
Yes, thank you, Mr. Chairman, Jeremy. First of all, to clarify, when you talked about distributing with editorials throughout the newspapers, you mean both approaching the editorial boards for them to do editorials and for us or you to do an op-ed to be widely circulated around the state? I just wanted to clarify that that's what you meant when you referred to.
Chair and Commissioner Bluestone, yes, we would certainly do the latter, which is write op-eds and try to place them in newspapers around the state. And I can see members of the various papers here with us today, and hopefully this committee, should the governor sign this bill, would be such an innovation and such an important committee for New Mexico's democracy that the newspapers themselves would also write editorials.
Thank you. Insofar as contacting all the retired judges of the Court of Appeals and the retired justices, I assume that the AOC or some group has a list of all of those retired judges that we could have you contact directly with a letter or email. Is that correct?
So Chair and Commissioner Bluestone, I have written to the Administrative Office of the Court's Director, Artie Pepin, for the list and hope that he'll provide it. I hope that they have it.
If I might just chime in on that, PERA is probably an even better resource.
I'll make a note of that, Chair. That's a good point.
The other question I have is about the proposal which you make for how to resolve any tie votes. And with all due respect to Commissioner Baker, I wonder if it would also be an appropriate method take the ranked choice voting system and just eliminate the person that has the last place from all of the commissioners, and do that until you get the tie resolved, rather than having it solely be Commissioner Baker's decision.
So Chair and Commissioner Bliston, I thought about using a traditional ranked choice, or proposing a traditional ranked choice method. The commission could certainly favor and adopt that method. I just think that allowing, in the event that there's a tie, that deferring to Commissioner Baker's choice is simpler than using a traditional ranked choice method with its iterative steps. And it also signals that ultimately the decision on who is appointed to the Citizens Redistricting Committee, which under the Redistricting Act is meant to be non-politicized, not in any way biased toward either party. I thought that a tie-breaking rule that allows for the independent member of the State Ethics Commission to break the tie would be more consistent with the intent of the Redistricting Act than the traditional ranked choice method voting. But I'm not wedded, and won't try to die on the hill on that tie-breaking choice if the commission thinks that traditional ranked choice is what it prefers.
Yes, thank you. I mean, I'm not wedded to it either, but I must say I lean more towards the ranked choice system. But I'd be curious to hear from Commissioner Baker and the others about that first before we vote on it.
Anything else, Stuart?
No, thank you.
Thank you. Governor?
Well, one comment, I think this is probably going to call for us to have our first in-person meeting in a year to do these interviews. I would prefer not to have to do these on Zoom. And I'm hopeful that staff and members are completely vaccinated by that time so that we can get together for an in-person meeting to do these interviews. And in terms of breaking the tie, you could just have one vote on breaking the tie, because that tie is a result of everybody's recommendations, and you could just revoke the two that have the tie and let the commissioners determine it that way.
Thank you, Governor. Commissioner Solomon?
Can you hear me?
Yes.
Yeah. There you
Okay.
go.
Thank you, Mr. Chairman. Kind of partial to chocolate cake, so because that makes me partial to the independent member of the commission here, Jeff. No, but seriously, I think I trust, and this is not saying that Stuart doesn't trust Jeff, but I trust the judgment of Jeff in this regard. I was just wondering, my question is relative to the members of the task force that participated in moving this whole redistricting committee forward. Are they going to be eligible for appointments here by either the legislature and or the commission? Or are they disqualified, having been participants in that task force that was initiated by New Mexico First?
So Chair and Commissioner Solomon, the no participation on the task force is not grounds for disqualifying a member of the redistricting committee. And the New Mexico First has very conveniently provided the list of all 122 applicants for that task force. And so we already have a source of at least non-Republican, non-Democrat applicants who are interested in redistricting in New Mexico that the State Ethics Commission could solicit applications from. And any of the Democrat or Republican applicants or members of the task force could be appointed by the legislative leadership, so long as they're not disqualified by other of the disqualification criteria that's in the Redistricting Act. And there is a few disqualification criteria.
Okay, well, thank you. I think that's good to hear. The task force did a marvelous job. And of course, I know that you were part of that process. So thank you.
Thank you, Commissioner. Commissioner Williams?
Yes, I have some questions. I am a little bit confused as to how the rankings will be developed. I mean, if you give them a 1, does that mean that's the best? If you give them a 2, that's the second best, or whatever. Usually with rankings, I'm familiar with that it tells you what 1, 2, 3, 4 stand for. So I'm not certain about how the rankings, how the numbers are to be assigned.
So Chair and Commissioner Williams, under the proposal that's in the meeting materials and on page 13 of the meeting materials, specifically, we have a kind of hypothetical choice about how the commission would decide among 5 potential desserts for the commission's hypothetical banquet, which 2 desserts it would have. And so if you look at page 13 and those 2 tables, that'll give you a sense of how the group's choice will work. And specifically in response to your question, the commissioners themselves will decide which applicant is number 1, which applicant is number 2, et cetera. And where 1 is the most preferred and 7 or 8 would be the least preferred. And like Commissioner Bluestone's round of golf and truth or consequences, the lowest score wins.
Right.
Well, I'm always concerned about ratings and rankings because in this case, they would be more subjective and it would be based on our opinion rather than any specific thing we could point to as far as what 1, 2, and 3, and 4 stand for. Okay, I have some more questions on the on June 4th. I don't know what page this is, but paragraph 3, it says, so for the 8 interviewed for the 2 non-major party positions, each commission will assign a preference ranking. Okay, I understand that. Now, will we be supplied with questions to ask each of the ones that we interview? Is there a set of specific questions, or would he make up our own when we're interviewing applicants?
Chair and Commissioner Williams, the staff could certainly provide you with a list of questions you might ask members or applicants for these positions. You'll also need to review the Redistricting Act if the governor passes it to get a sense for what the statute will require of these members. This committee is being tasked with a huge job. They have a ton of work to do, and their work is going to be complicated. And so the appointment process is by the State Ethics Commission. It's a very important one. These appointments are very important, and I think kind of overall you should be looking for both a commitment to impartiality as between the political parties that that might use the redistricting process to entrench political power or to gain political power. So the first I think value that you'd be looking for is a sense of impartiality. The second is a kind of sense of competence that these folks that are applying can understand the law that applies to redistricting and have a sense for how they might propose maps and work with whatever map drawing expert that this committee will retain. And then third, kind of work ethic, because this committee is being assigned a large task. But beyond those kind of general values, certainly the staff can help with proposed questions that you might ask to elicit your preferences along those values or other values that you might think bear upon the selection.
I would like to have some questions, since this is an area that I've never worked in and I'm not familiar with. So I would very much like to have some help with regard to questions. Now, I also, on paragraph 4, it says that for 2 non-major party positions, 2 applicants with the 2 lowest overall aggregate rankings will be appointed. I didn't understand that. The 2 lowest applicant rankings will be appointed. And then for the chairperson position, the applicants with the lowest overall aggregate ranking will be approved.
So,
I don't know what that means.
Chair and Commissioner Williams, again, this is why I kind of provided for the example of the hypothetical choice of which 2 desserts among 5 possible desserts the commission would like to have at their hypothetical banquet. And again, the process is roughly this. You'll conduct the interviews. You'll fill out a list from 1 being your most preferred to 8, assuming there are 8 applicants, to 8 being your least preferred. Each of the commissioners will fill out one of those lists. You'll send them to me. I'll add up each of the rankings for each of the applicants. And so if an applicant was the first choice of each of the commissioners, that applicant would have a number of 7, and that would be the lowest ranking. And that applicant would be the commission's most preferred and would be appointed. Is that helpful? And again, I would point you back to those 2 tables on page 13 of the meeting materials to try to clarify how this might work.
Yeah, okay. Well, I'll need a little OJT with some of your staff on this, but thank you. Appreciate it.
Okay.
Mr. Chairman,
Yes, Governor.
I could follow up on what Commissioner Williams is talking about. I think in order to treat every candidate fairly and equally, the commission ought to have a set of questions, and we'll just rotate taking turns to ask the questions. Then everyone is asked the same questions. Each commissioner can have 1 question or 2, whatever the case may be. But in my past practices, I've found that is the best way to treat everybody fairly, instead of each commissioner being inspired at the moment by a question they want to ask, but no one else gets asked that question. So I think what Commissioner Williams is proposing is the commission have a set of questions. We will each identify the one we want to ask. And if there's a second round of these questions, we can do that as well. But that treats everybody the same and fairly, and everybody answers the same questions.
And Chair and Commissioner Carruthers, I believe that's how the commission selected or conducted the interviews that resulted in the selection of Commissioners Baker and Solomon. And yeah, I was remiss not to include that point in the procedure, but I think, Chair, I think it's a good idea, and I'm happy to add it to this procedure.
Right. The only thing I have is that, and again, with all deference to Commissioner Baker, and I understand the optics portion of that, but I agree with just tiebreaker being a traditional tiebreaker, and that's that the commission vote between those two who tied. Because, well, yes, it highlights the independence to allow the independent to make the choice. I think the commission was delegated the task by the legislature of selecting, and I think it's more of a commission-wide decision if it looks that way. And so, not being, again, to use your phrase, I'm not going to die on the hill over it, but I think it makes more sense for the commission as a whole to break the tie. And that's all I have. Does anybody else have anything?
I've got a comment and a question.
Sure, Jeff.
Number one, I have no dog in this fight. If there's a tie, whatever is the consensus on how to break the tie, that's what we ought to do. And I'm happy to go with suggestion or go with another suggestion. It doesn't have to be me as the tiebreaker. My question is to Jeremy. When you put out the request for applications, was it your intention to indicate how much work is going to be involved so that people don't think they're just going to be sort of mailing this in, but they're actually going to have to spend a great deal of time?
But Chair and Commissioner Baker, in effect, yes, the application form that we've devised for soliciting and receiving applications asked applicants about their experience in redistricting, if they're familiar with this act, if they realize the amount of work that it will entail.
And I don't want to make this overly complicated, but is there a way to give an estimate on how many hours reasonably ought to be devoted to this?
Chair and Commissioner Baker, I haven't done that estimation, but I think it could be done. I mean, the act provides for a requisite number of open meetings prior to the creation of the maps. And I think based on that could be the source for, the minimum amount of time, that plus some coefficient of the amount of work it would prepare it to be ready for those meetings.
Thank you.
If I can follow up on that, please, it might be advisable at the very beginning. I think that's a good point, Jeff, that the person filling out the application is told at the beginning of the application that I'm hereby applying with the understanding that I understand there is a substantial time commitment over the next 18 months. I don't know how you would word that, but maybe just giving a heads up to folks and down the road showing that they were aware of that if there is an issue among them. But that's a thought.
And Chair, it would be a time period that's far shorter than 18 months.
Whatever the period is, because I'm not sure when it begins and when it ends, but yeah, whatever that's it. But that's not something I weigh heavily on, but just to follow up with Jeff's idea that it is, it's not a cocktail party thing. So anybody else have any questions?
Yes, I have a question. Are these people who are selected, are they volunteers or are they going to be paid?
So Chair and Commissioner Williams, the 7 members are entitled to per diem and mileage. As I mentioned, the redistricting committee was appropriated $300,000, and hopefully it will be able to quickly engage a staff member to help it run these meetings and to help it with its work. I also anticipate that it would have to contract with an expert that has some skills in map making, and those staff members or contractors would certainly be paid.
Are they going to be meeting in person or by virtual means?
Chair and Commissioner Williams, I don't know the answer to that question. They are responsible for conducting meetings that cover the entire state, and it's at the discretion of this committee how it's going to do that.
Okay, thank you.
Thank you. Is there anything further?
Chair, we,
Mr. Chair, I'll make a,
Thank you. That's what I was looking for, but we had to reconsider. But Stuart, I will trust you to tinker with whatever the language is. You go on a motion.
I was just going to make a motion to approve the proposed process for distribution and selection of our 3 appointments, with the one exception that we, as Governor Carruthers and you indicated, and I'm happy to agree to, break any tie votes with a separate vote by the commissioners on the tie.
Is there a second?
Second,
Okay, it's been moved and seconded. Is there any further discussion? Hearing none. Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes,
thank you. Commissioner Solomon,
Yes.
Commissioner Williams,
yes.
and the chair votes yes. The motion carries. Jeremy, thank you for all of that good work, getting us to this with no blood loss.
Mr. Chairman.
Yes,
Mr.
sir.
Chairman, can I ask one other question?
Yeah.
Okay, who's first?
Hold
Go
on.
ahead,
You are,
Governor.
Governor is.
I wonder, Jeremy, if you would craft a number of questions that might be utilized by the commission and send them to us, obviously before June 4th, so that we can all agree upon the set of
Right.
questions that we think are appropriate.
And I had a note to that effect that if anybody, it might be helpful to Jeremy, if any of the commissioners want to raise their hand and assist him with coming up with that. I'm sure he would invite the help. If I'm not.
happy to do it.
Yeah,
Thanks. So anybody that would like Jeremy to assist in that process, please involve yourself rather than look for a volunteer now. I know there will be at least one. So Stuart, did you have an item as well? A question follow-up?
Yeah, just consistent with that. I've been curious about how redistricting works in terms of protecting minorities from having their votes diluted. And I don't know how to ask the question, but it seems to me that if you have a community of interest that has like 100% Native Americans in it, that if you allow that whole district to be 100% Native Americans, and that actually dilutes the effect of their representational abilities. And I don't know if the magic number is 50% or how it works, but I'd like to develop some questions to get views from these applicants on how they want to protect minority rights and honor community similarities and interests without diluting the minority rights. So I don't know how to phrase it, but I'd like some help from you, Jeremy, and your staff on how to develop questions like that.
That sounds like you raised your hand to mix a metal to assist with Jeremy. And that's exactly the type of thing that I was looking for.
So Chair and Commissioner Bluestone, happy to help in that regard. I think in that particular instance, communities of interest is a traditional redistricting criteria under the equal protection case law for districting. Dilution in the way that you just mentioned is very much what the Voting Rights Act is attempting to prevent. And so I think part of what the State Ethics Commission is going to need to ascertain among the applicants is a familiarity with, especially the Voting Rights Act and the traditional redistricting principles and how they they get along in making redistricting decisions. So that's a great example that points to how complicated this area of law is and how contested it is and how important the commission's appointments are.
Thank you. Anyone else? Are we ready to move on to the next item? Okay. Number 6, Jeremy, the timeline for rulemaking on hearing on amendments to 1.8.3.
Okay, thank you, Chair. So coming out of the 60-day legislative session, and with assuming that the governor signs HB 244, this summer, the commission will need to amend its rules, certainly its rules of procedure at 1.8.3, and perhaps also its general rules at 1.8.1 to align the rules of procedure with the statutory changes that are being made by HB 244. Rulemaking on the rules of procedure is also advisable for a few other reasons. We've been running administrative cases now for about 15 months. And during that time, Walker and I have observed certain gaps, certain ambiguities that the parties and their counsel that have appeared before the State Ethics Commission have also pointed out. And so I think it's time this summer for the commission to, after kind of giving the car an initial drive for the first year, to go back and work on that. Next, as you'll hear in a second, myself and members of staff have been meeting with the directors of other ethics commissions in other states around the country, from Alabama to California. Over the past few weeks, we've had at least a dozen Zoom calls with directors and general counsels of other state ethics commissions. And so we've gotten a good sense for how the New Mexico State Ethics Commission's procedure is like and different than that of other states. And I think we're also at a point where I can propose some improvements based on how other well-established ethics commissions handle their adjudications. And so for that set of reasons, Chair and Commissioners, I think that this summer it makes sense to conduct a rulemaking on the Commission's rules of procedure. And in your meeting materials on page 32, I propose a timeline for that. And the timeline is roughly as follows. By May the 6th, the staff will distribute to the Commission a draft of amendments. During May, from May the 6th until May the 31st, commissioners will have the opportunity to make changes, suggest amendments, make language changes to the rules. And then at the June 4th meeting, which by now, as you gather, will likely be an all-day meeting, we'll issue these rules for notice and comment. And the rest of the timeline, Chair and Commissioners, just kind of follows the timeline that's required by the State Rules Act and the rulemaking rule. So after a notice, a public comment period, the Commission would then, at the August meeting, conduct a rulemaking hearing where it will receive public comment, both kind of orally at that meeting, in addition to the written public comment that would have been received up until the time of that meeting. And so with a rulemaking hearing to be conducted in August, the hope would be that the final rule could be approved and filed and published in the New Mexico Register by the end of August. And so by the end of the summer, the Commission could have updated its rules. And so with that, Chair and Commissioners, I'm happy to entertain any questions.
Mr. Baker,
No questions.
Mr. Bluestone.
Thank you. Jeremy, the proposal sounds fine. I just happen to know that I'm already committed to an out-of-state trip on the supposed August 6th meeting date. That will make it hard for me to participate in that. And I'm wondering, would it mess up the schedule much if the other commissioners were amenable to a different date, perhaps the next Friday, August the 13th? Or would that still be okay?
Chair and Commissioner Bluestone, it would only adjust this timeline based on the publication dates of the New Mexico Register. And so that's not a material change.
Okay, thank you.
Commissioner Carruthers,
No questions.
Commissioner Solomon,
No questions, Mr. Chairman. I don't have any trouble as well moving the meeting to the 13th because I have a commitment as well. Not on the 6th, but on the 4th. That's going to affect my ability to be coherent on the 6th. In other words, I'm scheduled to have a knee replacement.
okay. Well, I'm glad you clarified that.
Thank you, Mr. Chairman.
Thanks, Ron. Commissioner Williams?
Well, yes, on this issue, I have no problems with the date or anything like that, but I do have a question, and it has bothered me. I don't know if it's included in this rulemaking hearing, but is there any possibility we can change the ethics code that we develop from proposed to just ethics code?
So Chair and Commissioner Williams, you're right that issue really has nothing to do with the rules of procedure. And the answer is no. The State Ethics Commission Act, unlike some other state ethics commissions, but the New Mexico State Ethics Commission does not have the power, the delegated legislative rulemaking power to promulgate a code of ethics that's substantively binding for the state or local employees in the state of New Mexico. So the delegated power in the State Ethics Commission Act is to create a proposed code of ethics, and the commission has done that.
Thank you.
All right. Can we informally, and we can maybe have to do it, we'll do it formally later, but is everybody okay with moving the August meeting to the 13th? Let me know if that's a problem, anybody. Okay. So looks good. We're all in agreement. We'll move that. And I'll underscore that at the end of today's meeting. Okay, item number 7, the update on the October 1st, 2021 special report.
Okay. Thank you, Chair. And Commissioners, if you haven't noticed by now, we're quite busy. There's a lot going on.
Yeah.
And this is the next unrelated and very large item that we're working on. So on October 1st of 2021, the State Ethics Commission under statute owes the governor and the legislature a report on recommendations regarding the commission's own jurisdiction, whether or not to enlarge that jurisdiction, change that jurisdiction, and if so, how. The staff have been working diligently on this project, and as you know, we have engaged a new hire, a special projects coordinator too, Dr. Michael Kiley, who is with us this morning, who I'd like to introduce and allow him to say some words on this project in a moment. But in the main, Dr. Kiley, myself, Sunny have been collecting a lot of research, conducting interviews with the directors of other state ethics commissions to understand how their jurisdiction is different than that of New Mexico, and how it impacts their work and their budget, their portfolio of work, and the attributable costs to the work. Part, perhaps the lion's share of this project is the question, if and to what extent the Ethics Commission's jurisdiction for administrative complaints should be extended to cover the officials and employees of local governments, of local public bodies in New Mexico. And to that end, that's been a particular topic of conversation between us and directors of other state ethics commissions, where we believe those commissions have some oversight role or jurisdiction for local public bodies in other states. In addition, on this project, we've developed a survey for members of New Mexico counties and of the Municipal League. And I've been in conversation with the director of New Mexico County, Steve Kopelman, and the director of the Municipal League, AJ Fort, on the project. And so we'll also be soliciting the input of the state's municipalities and counties. The project isn't only about whether or not jurisdiction should be expanded to local public bodies. It could also include whether or not the subject matter jurisdiction of the State Ethics Commission is the right set of statutes or constitutional provisions for the commission to oversee. And that gets into questions about whether the specific statutes that the commission oversee, whether or not internally their scope makes sense. Some of the statutes only apply to state employees, but not local. Other of the statutes apply to any public officer or employee of the state. And so there's also a part of this project that, that's not only looking at what in the law is called the personal jurisdiction of the commission, whom the commission has jurisdiction over, but also its subject matter jurisdiction, whether or not the specific statutes and constitutional provisions that the commission oversees is the right set. And so I want to turn it over now so that you have a chance to meet and to hear from Dr. Kiley, who I'm very pleased is on board with us, at least until July of this summer. And just for him to give you a sense of the research he's doing and kind of the ground that he's broken on this project so far. So Mike, please take it away.
Well, it's a pleasure to be here with you this morning, Mr. Chair, Honorable Judge Lang, Mr. Commissioner, Governor Carruthers, and members of the commission, Director Ferris, and colleagues, members of the public and interested organizations. It was my occupation before joining the commission to be traveling from corner to corner of the state, picking up hospital lab samples and COVID tests and bringing them into a Tricor laboratory. And so I had the opportunity over the last 2.5 years to visit nearly every town and county in New Mexico. I don't know if you're aware, but that's how remote hospital and clinic lab tests get to Tricor. They're transported by private car by independent contractors. And it was a great joy to see so much of New Mexico and see animals I'd never seen, like large two-horned antelope in the White Sands area going to Ruidoso. But anyway, so I have profited from meeting and traveling through New Mexico, as well as undertaking this project now. As Dr. Ferris said, I've been working with Sonny Haqqani, and we have together been assembling the material that constitutes the research we have collected so far. And I'll give you some of the substance. If I'm getting too deep, I trust the director will rein me in. And I have no objection if you have a question as I'm going through this and interrupt, but pursuant to your rules. I'm going to move to a document on my computer, my laptop. So if you raise your hand, I won't see you, but I know that's not the way it's done. Just a moment. The research we did began with a question of how many people are in New Mexico and how many work for the government or a government at some level. And we benefited from information from a variety of sources, the Bureau of Labor, Business Information Center at UNM, and other sources. But what we determined was that there are about 90,000 non-federal government employees and officials in New Mexico. 45,533 work for the state of New Mexico in some capacity. Those are, as you know, as Dr. Ferris said, are currently covered by the commission now, the State Ethics Commission. The others who aren't comprise another half of the total non-government workforce, totaling, according to the Bureau of Labor Statistics, 92,557. And of those, of that half, about another 45,000, 7,629 are municipal officials and employees. 303 are county officials. 484 are county employees, and 29,608 are special district employees. Those are the people we'll be talking about in terms of personal jurisdiction. And if there are any questions on those numbers, I'll stop and inquire.
Can you
Anybody?
just run through those one more time, please? You said it's about 45,000 non-state but local employees, and that breaks down, did you say
That's correct.
7,400 municipal?
That's correct. Let me repeat the numbers as I went through them the first time. The municipal, 7,629. County elected officials, 303. County employees, 9,484. And special district, 29,608. And as I said, basically half of those individuals, those people have personal jurisdiction. The State Ethics Commission now has personal jurisdiction. The remainder, the other half, they do not. And we will be proposing, in terms of a number of options. Right now, we're looking at the number of 4 options, a way to leave things alone or to cover those individuals as they pursue their work in the non-federal government. We asked any other questions on those numbers?
Yeah, can you just give us a little flavor of the 29,000 special district employees? Who are these types of people? What are these special districts?
Well, for one thing, they're school districts that are not part of a municipal government. So all of the school districts comprise a group, managers and employees who are not presently under the commission. The next large group, I think, is the statutory conservation groups that mainly deal with water, canals, and irrigation. Volunteer fire districts would be another group. These are, from one perspective, these groups are largely invisible. We don't see them when we're looking at government per se, but they are special districts and do have, at the minimum, the ability to raise operating revenue by passing local mill levies.
Thank you.
You betcha. So we looked at that and said, okay, this is the group of people we're looking at. We certainly do have a group of people that are not covered. There's no question about that. The next we said, who has ethics structures in place now, or at least amenities such as online portals that allowed the residents and citizens to contact the governing body. The data is that, and what we found was that there are certainly gaps in ethical coverage. Without going into detail about something that you're surely already aware, the Rio Grande Valley, Central Valley, which is to say Albuquerque to Santa Fe, the cities and counties do have ethics structures in place. Las Cruces and additionally does have ethics structures in place. The counties in that area, Bernalillo and Sandoval and so forth, do have ethics structures in place. However, outside of that, in general, I'm speaking in general, I could be more specific, but outside of that, there is very little in the way of ethics structures and something of ethics functions operating in terms of, as I said, these portals. And I will take a moment just to acknowledge what we all understand, because it will happen later this morning here. The device of executive session certainly exists everywhere that allows public governing bodies to convene to deal with a issue that might be considered ethical in nature. So this exists too, and I don't believe it's possible to really say how much of that goes on because it's all confidential. The cities that have ethics structures are, of course, Albuquerque, Santa Fe, Las Cruces. One of the counties, one of the cities has a ethics body in place that just concerns itself with elections, and that's Las Vegas. And one of the counties created about the same time that the State Ethics Commission was created a county ethics panel, and that's Roosevelt's. However, their panel, in my impression, and this certainly carries no authority, my impression is it would be a problematic structure because the designated ethics structure is the county commissioners themselves. So clearly, if all of them were the subject of an ethics complaint, that would be difficult. And also, even if just one of them was, then that person would probably have to recuse. But otherwise, the rest of the state is pretty bare as far as ethics structures similar to the State Ethics Commission. Shall I pause here for any possible questions?
I have a question. With regard, you say ethics structure, does that mean they have an ethics code in place?
Mr. Chair and Commissioner Williams, I'm using it in the old sociological sense that, for example, the State Ethics Commission is an ethics structure. If there is no dedicated panel like that, then I considered whatever else might be there just an ethics function. And for example, some public bodies have a code for the county commissioners. So it's a specific code. Some have general codes, which are nothing more than to say, we expect our public officials to behave according to standards for their profession. And that is as lengthy as it is. So there's a wide variety. The things I am referring to as portals are things that are in general use, such as functions, things that are in general use for a wide variety of things, such as paying utility bills and so forth, which allow online contact with the governing body through an online portal. And so it's true that a complaint such as I saw a county backhoe on the lawn of my neighbor's house, how come, that kind of thing could be submitted, but there's no telling what happens to it after that.
Thank you.
Sure.
Commissioner, hold on just a second. Any of the other commissioners have any questions at this juncture?
Okay, thank you. So that is what we determined as far as what we have now. So there is a gap in ethics structures for most of the state. So let me continue as I scroll down a little bit here.
Please.
In our report, we'll detail this as much as space permits. And then all of the information I'm relaying to you has been archived and is available for further review if anyone needs to. The next thing we said was, let's look at the other states. And as Director Ferris mentioned to you, we have done so. And what we first found out is that about half of United States states have ethics commissions, in addition to one of the territories, Puerto Rico, that also have local jurisdiction, which is to say counties, municipalities, special districts, or some of those. And there was no consistent pattern. If one wanted to say the most prevalent pattern was what it is, and that would be complete coverage. And we found only one other state that did a extension or expansion and enlargement of jurisdiction after its original creation, and that was Oklahoma. So the states that have local jurisdiction largely had such from the beginning, and the states that do not, similarly, they did not have it from the beginning. We also found out that, well, as I said, only one other state did an enlargement such as we're looking at. So let me move along in my document here. We looked at the information that was available through organizations such as COGL and found that we needed to get more because what we found, for example, was there's a uniformity of ethics laws across the country generally with individual state variation. For example, conflict of interest, revolving door, these were all similarly covered by the State Ethics Commission. That was very similar. But we discovered that we needed to do more. So we began speaking with the other state ethics commission directors. And at this point, we have reached quite a few of them, probably 2/3 of those that we wanted to try to reach, the 25 that have local jurisdiction. And these were very informative. I won't go into detail on them, but one of the common patterns was that when they have local jurisdiction, it expands the workload at least by doubling it. This number we got uniformly across the people we talked to. We said, what do you think is the effect of going from original jurisdiction with covering just state legislature and executive officials and employees to picking up local political subdivisions? They said at least double, sometimes triple. And the percentage local to state volume for the committees, the commissions, was very consistently in the estimated in the range of 70 to 75%. So there's a significant amount of volume that's there. There was a lot of subjective information that was gleaned, for example, almost to a commission, to a state. The ethics commission directors said this was an extremely valuable part of their work. And a lot of that is education. They uniformly said, you want to do as much education as possible to prevent ethical offenses. So they try to do education as much as possible. Some of them do some driving, but most of them try to arrange appearances at association meetings to try to get the word out to as many people as possible. But they were all very supportive. Some said that they think that the local work that they do made more difference in people's lives than what happens in Santa Fe and in our own case in Albuquerque. They felt it was extremely important to do it. An interesting thing too is that, as you know, New Mexico was one of the latest states to pick up, to create an ethical commission. There is one remaining state, and that is Wyoming. So every other state now has, other than Wyoming, now has an ethical commission. And another thing that we found out is that we're going to talk a little bit about how we're approaching the question of cost, which is the least developed of all of our data right now, because some of the information is very difficult to get, and we're working on getting that in one way through the questionnaire that we're sending out to all the local officers. But one thing we did find out is that, and this is just simple math, that the cost to each citizen for the State Ethics Commission right now in round dollars is $2 a year. That is, we have a $900,000 budget and 2 million population. So if you doubled or tripled our budget, it would go from $4 to $6 a person. Another thing we located was a very interesting study that began with federal criminal convictions of local political officials over a 10-year period, and the total of convictions from Department of Justice information was 25,210. And of those, 59 were from New Mexico. That is, they were convicted in federal court for federal offenses in connection with their performance as a local political subdivision official. And the study went on to say that if you look at the pattern across the states, you could save in average $1,300 per person per year, just by the highest and most egregious states in terms of convictions, if they simply move down to average. So that's really the only number that's available to say what does it save to have local and political subdivision coverage by the ethics panel. There are a lot of questions as to what it might cost. There's that information on savings, and we're looking at that now. For example, we're going through all of the budgets of the counties and municipalities and looking at their expenses, so much as it has been itemized in line items on budgets, that they pay for risk management. And it is a significant item in most of the budgets. And we look at a risk management department if it exists, and the cost, county attorney, the amount, and all the way down to something very specific, which is not always available, the amount they pay in deductibles under their risk pool that they have with the state organizations that do risk pooling for the counties, to look at what they might be spending with a change such as we might, one of the options we might suggest, or save. For example, in Massachusetts, we learned from the director, and they have, of course, a fairly large group of employees, about 400,000. They basically serve as a free source of free legal advice on ethics matters to people in small towns. And they, if someone has a question and they don't have a town attorney in a small municipality, they can call the ethics panel and the question will be answered. And so they don't need to be paying for an attorney for things like that.
Mike, I appreciate that that thorough overview. I'm going to stop you there because it's a lot of detail. But just to summarize for the commissioners, we're soliciting the input of the county and the municipal governments. We're trying to understand to what extent they have ethics codes and ethics organizations, boards or panels. From our conversations with other state ethics commissions, we understand that this kind of expansion for local public bodies is very rewarding and very helpful for the state in the view of the other state ethics commissions, but that it would produce a very large increase in the state ethics commission's work, double or triple what we currently have in order to carry this function out. And in the draft recommendations that we're hoping to provide you later in the summer is that the commission, instead of kind of providing a yes or no recommendation on expansion to the officials and employees of county and municipal governments, rather the commission provides a kind of range of options. What status quo looks like, what a limited expansion looks like, what expansion of personal jurisdiction for all those offices would look like, and what some other kind of relationships with county and local officials might look like. For instance, requiring that county and municipal governments designate a chief ethics officer, like how they have to designate a chief procurement officer, and then have an employee in those governments kind of be the point person for the ethics statutes as they apply to county and local governments, and also a point person to liaison with the State Ethics Commission. So we're looking at a range of different scenarios, different proposals to offer in way of recommendation. And we're currently collecting research as to what each of those might cost the commission, how it might benefit the local governments, and indeed whether or not this is something that in their view they would think is helpful or necessary. And so with that, Chair, I would suggest we have a round of questions, and we've been going on this for a while, but happy to continue the discussion at the commissioner's convenience.
Thank you. Commissioner Baker, do you have anything?
No questions. Are we going to get a written report at some point from Mr. Kiley?
So Chair and
yes.
Commissioner Baker, yes, the plan is by the August meeting that the commission be provided with a draft of this report, and that the commission has a chance to review it and work on it before it's due to the legislature and the governor on October the 1st.
Great, thank you.
Commissioner Bluestone?
Thank you, and thank you, Dr. Kiley. It was very informative, very helpful. The only question I was curious about to follow up on, when you talked about those 29,000 special district employees, and you mentioned school districts, was that including teachers as well, or was that just school district employees?
I'm sorry, was it including what? I didn't quite catch what.
Teachers.
Once again,
Teachers, was that including teachers or
Oh,
just
yes,
district
yes.
employees?
the entire budget for a school district, yes.
Okay,
We clarified that with Brenda in Finance and Administration, and she said that it includes, when we're talking about a school district, it includes everything but the state employees who teach at, for example, the School for the Deaf. But if the schools are not part of the municipal government, then they're special districts.
thank you.
Everything.
Thank you. Commissioner Carruthers? Governor, you have any questions?
I thought I heard that there would be some kind of survey to gauge the receptivity or the enthusiasm of county and city governments, for example, being included under the State Ethics Commission. Is that correct?
Chair and Commissioner Carruthers, yes. And I've provided that survey to Steve Koppelman at New Mexico Counties already, and have spoken about the same with AJ Ford at the Municipal League, and intend to get him the survey next week.
these numbers, what would you speculate the enthusiasm would be of both the city and the county employees?
Chair and Commissioner Carruthers, from conversations with Steve Koppelman and AJ Fort, I think it might be a little different between the counties and the municipalities. My understanding is that the counties feel particularly burned by the Civil Rights Act and this past legislative session, which resulted in the creation of a new private right of action that subjects officials and employees of county governments to perhaps increased causes of action and associated litigation costs. And my speculation with respect to the counties is they might see a private right of administrative action filed in the State Ethics Commission as an administrative adjudicatory body in a similar way. My conversation with AJ Fort was more sanguine with respect to how the municipalities might perceive this, and that tracks with Mayor Sanchez's initial set of comments and observations to this commission when we kind of broached this project.
One comment, we did hear back from Mr. Koppelman on, in that vein, on the concern for increased legal costs. And we've addressed that some, and we'll continue to look at it because we know it's a major thing. And we also know that some counties are fiscally in perilous circumstances. So we're not unsympathetic to that. So we're looking at that and trying to give it more attention.
Anything else, Gov?
I'm good.
Thanks. Commissioner Solomon?
There we go. Just with regard to the education component, I know we've talked about this before. How did the different commissions handle that? Was that another area in which they had to increase staff and therefore costs?
So, Chair and Commissioner Solomon, the theme seems to be, before the pandemic, there was a lot of road shows. Since the pandemic, it's moved over to online platforms. And we had a good conversation with the director of the Massachusetts Commission, as you heard Mike allude to. And they're actually receiving a capital appropriation from the Massachusetts General Assembly this session to develop a kind of software, a training software that they couldn't afford out of their normal budget appropriations. And that's a very good idea for the commission to pursue in a future legislative session to develop some kind of standard software using a capital appropriation for trainings. I'll just remind the commissioners that that trainings are something that the staff kind of are continuing to do. Walker and I gave a training to the regions of Eastern last week. Next week, I'll be providing a training to municipal officials that are part of Leadership's New Mexico's kind of Better Municipal Government program. Becky recently provided a training to municipal employees in Los Ranchos and Corrales, and Walker and Becky are meeting with the general counsels of various state agencies and rolling out trainings is part of what's being discussed in those meetings. And that includes the boards and commissions that fall under RLD. So this is, to the extent that we have the staff and the resources to kind of continue to provide these trainings, it's something that we do, and all of our trainings currently, Commissioner Solomon, are online.
Anything else, Commissioner Solomon?
No, Mr. Chairman, thank you. Appreciate
Thank you. Commissioner Williams?
Yes, I'm a very strong advocate for having the commission include counties and cities. And the reason for that is that I have been a consultant to several of the cities and counties, and I have found a lot of corruption, and basically, which has not been addressed. And there was nothing, even though they had codes of ethics, there was no one who was looking over their shoulder to enforce those. And some, in 2 cases, were pretty serious. So for that reason, I'm an advocate for taking over the counties and cities, because I do not believe, on my own experience, that there is good oversight, even with the state auditor auditing some of these counties and cities. There's a lot that drops through the cracks and is not found for some reason. So my comment is I'm a strong proponent of us having the cities and counties. Thank you.
Thank you. Jeremy, anything else, Dr. Kiley?
Not for me. Thank you very much, Mr. Chair.
Thank you. Thank you very much, sir. Jeremy, anything more on this issue?
No, Chair, we're ready for the next
Great.
item.
Thanks very much. Okay, we will now move to agenda item number 8, which is advisory opinion number 2021-06, page 34 in your materials. Jeremy?
Thank you, Chair and Commissioners. This is another procurement code advisory opinion. This particular advisory opinion is one that was initially issued through an informal letter opinion and through the Commission's rule that allows the conversion of informal letter opinions into formal advisory opinions. That's the posture in which I'm presenting this formal advisory opinion today. So the question that this advisory opinion addresses is the following. Under the procurement code, a sole source procurement contract has to be noticed on the website of the State Purchasing Division or the Central Purchasing Office and the Sunshine Portal before the sole source contract is effective. The question presented is whether or not those same public notice requirements apply to the amendments of sole source contracts. And the advisory opinion concludes that yes, indeed, the public notice provisions that require public notice for sole source contracts also apply to amendments for sole source contracts. And really it's for 2 reasons under the state's procurement code. The first is that an amendment to a sole source contract might affect the applicability of either the state purchasing agent or a central purchasing office determination that the contract is indeed subject to a sole source procurement. And so that's one reason why the contract would need to be publicly noticed, so that that other players in the market have the ability to verify, to check, and to verify that indeed they don't provide that kind of service or goods to the state. Second, posting the notice of the amendment prevents a kind of unfair gamesmanship that has occurred in state agencies in the past, whereby a state agency, central purchasing office, declares a certain procurement as eligible for sole source. The sole source contract is noticed. The contract contains a relatively minor compensation term or scope of work. And then after the notice period is over and the contract is awarded, then the state agency dramatically increases through a contract amendment the compensation term and the scope of work of the sole source contract. And that's unfair gamesmanship, because if you're another player in the market, you might not be incentivized to check or to protest a sole source contract that's for a relatively insignificant scope of work with a relatively insignificant compensation term, but you would very much check and potentially protest a sole source award at a much larger compensation term or a much larger scope of work. So in order to prevent that kind of unfair gamesmanship, The best reading of the procurement code on this question is that amendments to sole source contracts also need to be noticed in the same way that sole source contracts themselves are noticed. And Chair and Commissioners, that's roughly this advisory opinion.
Is there a motion and a second to issue the advisory opinion as it is written, after which we will consider, after somebody will make and second it, and then we'll hear any discussion. Is there a motion and a second?
So moved.
Second.
Thank you. It's moved and seconded. Any discussion or questions?
Yes,
I'm sorry.
I have a question. I
Yeah,
have a question.
Please go ahead.
Is there a limit on the value of a sole source contract? I mean, is it, can you have a sole source contract for, say, $1 million or 500,000, or is there a limit on what a sole source contract can be made for?
Chair and Commissioner Williams, that's a good question. I don't have 100% confidence in the answer. I think that the answer is no, that sole source procurement is a separate procurement vehicle that doesn't have the same type of limits that you might see in terms of professional service contracting as to whether or not those have to go to RFP or not. But if Walker or Wendy or Becky remember differently about the procurement code, please jump in and correct me. Okay.
And then my second question is, how is the sole source contractor determined? Do they just put something out on the street and say it's a sole source, or do they actually know some company that provides this kinds of service and then just goes to that company and provides them a contract?
So, Chair and Commissioner Williams, the government agency that would be the initial entity, whether it be a state agency or a local government, would be the initial entity to find the vendor that they want to contract with. And if they believe that that's the only vendor that can provide the services or the tangible items of personal property, then either the state purchasing agent or the central purchasing office of that entity is the office to provide to issue, to decide and issue a sole source determination. And whether or not it's the state purchasing agent that does it, or the central purchasing office of that state agency, or the local government, is a little complicated. Of course, for local governments, it's not going to be the state purchasing agent, but there are certain contracts where in state government, the state purchasing agent is not the office that makes the sole source determination, but rather it's the central purchasing office of the particular state agency. That's the case, for example, with professional services contracts, sole source professional services contracts. And that's really the instance where the notice and protest provisions of the procurement code keep the sole source honest. Because if you have the secretary or the deputy secretary of a state agency that selected a vendor that the agency wants to contract with, you know, and if it's a professional services contract, it's the same agency employees in the central purchasing office that make the determination. And while the CPO is subject to a world of ethical constraints, there might be a little pressure there with respect to making a determination that the contract is subject to sole source. And again, that's really where the notice and protest provisions of the procurement code keep sole source as a procurement vehicle that has integrity and that's fair.
So after the sole source contract is issued, people are notified that there has been a sole source contract issued?
Correct.
Okay. And the people who would be notified were those who thought they should be on that sole source. So they have the same kinds of things to offer that the sole source contractor got. But
Chair
then,
Commissioner Williams, that's not exactly how it works. There's a notice that goes out over the website or the Sunshine portal, such that any players in the market could then review the proposed sole source contract and determine whether or not they also provide that kind of service or those kinds of goods. And if they believe that they do, they could contest the sole source determination with the state purchasing agent. They could file a protest, and ultimately those sorts of protests are adjudicated in state district court.
so if an amendment is provided to the sole source contract and it changes in some respect what the services are to be provided or it's adding on, so you can protest the amendment if you feel you should have been given the opportunity to have a sole source contract, and the amendment sort of changes what the sole source contract, or it adds on to the sole source contract. And people who think they could have provided the service can appeal the amendment.
Chair and Commissioner Williams, I think that's a fair implication of this advisory opinion, that the amendment to a sole source contract also needs to be noticed so that the market can verify that the sole source determination to the original contract also fairly applies to the amendment.
Thank you.
Any other commissioners have any questions or remarks? Okay, we'll go ahead and call a question. Commissioner Baker.
I vote to approve.
Thank you. Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams.
Yes,
Chair votes yes. Let the advisory opinion in 2021-06 issue. Thank you. And the next matter, item number 9 on your agenda, which is correspondent to page 41 in your materials, is for the commission to take up the matter of advisory opinion number 2021-07. Jeremy.
Okay, thank you, Chair. Commissioners, this is the second advisory opinion for today. It also arises from a request and an issuance of an informal advisory letter that I received during the session. The question is whether or not legislators who are respondents in administrative complaints pending in the State Ethics Commission may vote on proposed legislation that affects the State Ethics Commission. And the advisory opinion concludes that the answer is yes. They can vote on legislation that affects the State Ethics Commission. And there's kind of 3 elements to the analysis. The first is that the provision of the Governmental Conduct Act that provides for disqualification of public officers or employees' official actions that directly affect their financial interests, that provision of the Governmental Conduct Act, Section 4B, is not one of the provisions of the Governmental Conduct Act that applies to legislators. So the Governmental Conduct Act's only disqualification rule, or its main disqualification rule, isn't a statutory provision that applies to legislators. Second, the next point of analysis is that the section of the Governmental Conduct Act that does apply to legislators, Section 3, in particular Section 3A, which under the Gutierrez Court of Appeals holding is still a provision of the Governmental Conduct Act that is applicable. That provision requires that legislators use the powers and resources of their office only to advance the public interest and not to obtain personal benefits or pursue private interests. But the advisory opinion reasons that provision does not require recusal on any vote because legislators cast their votes to that provision requires that legislators cast their vote for the public interest. It doesn't require recusal in the case of a potential conflict. But the advisory opinion notes that voluntary recusal by a legislator on any vote would certainly be a defense to a kind of Section 3A claim. And then the last point of analysis in this particular advisory opinion looks back to the speech or debate clause of the New Mexico Constitution, which by its text and by the Supreme Court speech or debate clause that also is a fair guide to how the New Mexico speech or debate clause would be interpreted, protects votes by legislators from being questioned in any other place, including the State Ethics Commission. And so that constitutional provision, I think, also provides a kind of not only defense, but a kind of jurisdictional bar against any claim brought against a legislator for failure to recuse on a vote, including the State Ethics Commission. And that constitutional amendment also bears, or that constitutional provision also bears on the analysis. And so to conclude, the answer is no. A legislator is not required to recuse from a vote on legislation affecting the State Ethics Commission when that legislator themselves is a respondent to a matter pending in the State Ethics Commission. And so, Chair, I would ask that for a motion for the commission to approve the advisory opinion, but I would also ask that the advisory, the penultimate sentence in the advisory opinion, the last sentence in the analysis section before the conclusion, be excised. I no longer think that sentence is necessarily accurate or informative of the analysis on this question. And that last sentence just it relates to how the speech or debate clause interacts with the Governmental Conduct Act. And as the commission knows, the staff have had several occasions in the past weeks to think long and hard about the speech or debate clause. And while I'm fairly confident that the State Ethics Commission doesn't have jurisdiction for Governmental Conduct Act claims based on votes taken in the legislature, that the Governmental Conduct Act still might speak to that question, but it's a claim and a question that the Legislative Ethics Committee and the two chambers themselves would have to decide. And so I recommend removing the penultimate sentence in the advisory opinion, not to any way prejudge how a Legislative Ethics Committee or either chamber would consider a GCA claim based on a vote or a failure to recuse.
So just to be clear, Jeremy, what you're suggesting is that the motion be crafted to approve the advisory opinion as drafted, and excising that what I read to be the penultimate sentence is for this reason, the Governmental Conduct Act.
Yes, sir.
Just so we're all clear. Okay. With that edit, is there a motion and a second to approve the advisory opinion, and then we'll go to discussion?
So move. So move.
Is there a second?
Second.
Thank you. All right. Is there any discussion?
Yes.
Make a comment.
Go ahead. We'll go in alphabetical order then. Commissioner Baker?
Yeah, there's this shows there's a distinction between what may or may not be ethical and what may or may not be legal. And this opinion is based on the law, and that under the law, a legislator can in fact participate in a vote involving the Ethics Commission, even if he or she is the subject of an administrative complaint.
Right. Commissioner Bluestone, anything?
No, sir.
Commissioner Carruthers,
No,
Commissioner Solomon,
No, thank you, Mr. Chair.
thank you. Commissioner Williams, you had something?
Well, I had a question with regard to recusal. But in the course of having a voting on some issue in which the state commission, ethics commission is involved, I assume that a person, legislator, can recuse themselves if they see that might be a conflict. And could anybody, let's say something to that person if they vote and the vote is adverse to the Ethics Commission? Can someone stipulate during this legislative meeting that this may be a form of reprisal, that their vote against the Ethics Commission could be a form of reprisal?
Chair and Commissioner Williams, sure, someone could make that claim, make that statement. I think that any kind of alleged impropriety or claim of violation of law based on the legislator's vote would have to be an issue that is handled by the Legislative Ethics Committee and in the ultimate instance, that particular chamber that the legislator is a member of.
Okay, thank you. No question.
Thank you. There being no further discussion, the question is called. Commissioner Baker?
I vote in favor.
Thank you. Commissioner Bluestone?
Yes.
Commissioner Carruthers?
yes,
Commissioner Solomon?
Yes.
Commissioner Williams?
Yes.
And chair votes yes. Let the advisory opinion as drafted and amended to excise that one sentence is approved and let it issue. Should we take a stretch break while we go in? So let's entertain a motion in a second to go into executive session, and we'll take a break while all that gets ordered up. So is there a second?
Second.
And
Thank
Chair,
you.
before you call the vote, just to make clear that the commission's going into executive session under subsections 2, 3, and 7 of section H of 1015-1 of the Open Meetings Act.
Thank you for clarifying that for the record, Jeremy. All right, Commissioner Bluestone or Commissioner Baker,
What time do you want us back?
just 5 minutes-ish.
Yeah, I vote to go into executive session after a short break.
Thanks. Commissioner Bluestone,
Yes.
Commissioner Carruthers,
yes.
Mr. Solomon,
Yes.
Commissioner Williams,
Yes.
chair votes yes. Okay, we are now going into executive session.
All right, we are back from executive session. Jeremy or Judge Lang, if you want to take things away for now.
Judge Lang, all right, asking you to unmute.
Oh yeah, sorry about that.
There we go. Okay, are we ready to go?
Yes, sir.
Thank you, Walker. We are back in the public session, and next on to item number 13, which is actions on administrative complaints. Jeremy, you want to run through those, beginning with or Walker, whoever is the appropriate handler?
Sure. I can take the,
Yeah.
I would, commission staff would ask for a motion to instruct the executive director to continue the commission's investigation of complaints 2020-07 and 2020-040. I think that's, we can address two in one fell swoop here.
Is there a motion and a second?
So moved.
Second,
Any further discussion? Hearing none, Commissioner Baker,
I vote in the affirmative.
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
Yes,
chair votes yes. Motion carries.
All right. Jeremy, do you want to propose a motion on 2020-31, or do you want me to?
I will. So commissioners, the staff seeks a motion for the commission in administrative case 2020-31 to forward the claims over which the commission has jurisdiction under the Financial Disclosure Act to the Secretary of State pursuant to the joint powers agreement between the Commission and the Secretary of State for shared jurisdiction for the Financial Disclosure Act. While noting that the claims that the Commission has jurisdiction for alleging violations of the Governmental Conduct Act remain pending, subject to the State Ethics Commission Act and the Commission's rules of procedure.
Thank you. Is there a motion, a second?
second,
That motion.
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
yes,
chair votes yes, motion carries. Next item.
Okay, thank you, Chair. On administrative case 2021-04, the staff seeks a motion for, in this administrative matter, for the commission to dismiss the section 1016.3A claim and the section 1016.3B claim for lack of jurisdiction, and to refer the same to the interim legislative ethics committee.
Is there a motion and second?
I move.
Second.
Thank you. Motion has been moved and seconded. Commission, any discussion?
I am recused on this matter, am I not, Jeremy?
Thank you.
Correct.
Thank you, Commissioner Bluestone. So Commissioner Baker,
Yes.
Commissioner Bluestone is excused. Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
Yes,
chair votes yes. Motion carries. Thank you. Next item.
Thank you, Chair. In administrative case number 2021-05, the commission staff seeks a motion for the commission to dismiss the complaint for lack of jurisdiction.
Okay, is there a motion and second?
So moved.
Second.
Second.
All right, motion and a second. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
yes,
chair votes yes. Motion carries.
Thank you, Chair. In the next case, administrative case number 2021-06, the staff seeks a motion that the commission dismiss the complaints, the claims in the complaint for lack of jurisdiction.
Motion and a second.
so move.
Second.
Thank you.
And Chair, I'll note that Commissioner Baker is recused from this case.
I was about to ask that. Okay. So Commissioner, any discussion? Hearing none. Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams,
Yes,
and the chair votes yes. And then there's one other remaining, right, Jeremy?
Yep, thanks, Chair. So in administrative case 2021-08,
I believe it's
Okay.
2020.
No, thank you, Chair. It's 2021-08, and the commission should note that that's an error on the agenda, that the case is 2021-08. 2020-08 has long been disposed of.
Thank you.
So in the administrative case 2021-08, the commission staff seeks a motion that the commission dismiss the claims in this administrative matter for lack of jurisdiction and refer the same to the interim legislative ethics committee.
Thank you. Is there a motion a second?
So move.
Is there a second? Thank you, Commissioner Solomon. Okay, so any other discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Solomon,
Yes.
Commissioner Williams.
Yes.
Chair votes yes, motion carries. Thank you. I believe that concludes agenda item 13, correct?
Yes, sir.
Correct. And I'll just jump in here on the public comment item. I would ask that participants who seek to make a public comment, so we don't have to go through a list, raise their hand. If you're on Zoom on a computer, there's a button at the bottom of your screen to raise your hand and indicate your desire to make a public comment. If you are on the phone and attending and you'd like to make a public comment, press *9 on your handset. I previously received a message from, let's see, Lilia Irvin Vitella. I don't know if she's present here. I can open up the public comment for her if she's still here. Yes, she is.
Go ahead and steer this vessel, would you please, Walker?
Sure.
Cliff Reese has indicated he would like to make public comment, I believe.
Okay. Ms. Irvin Vitella was the first to ask, so I'm going to ask her to unmute and see if she'd like to make a public comment.
Go ahead.
Thank you so much, Mr. Chair, Commissioners. My name is Lily Irvin Vitella, and I'm the President and Executive Director of New Mexico First. And again, I just want to extend a big thank you to you all and to Director Ferris for serving on the redistricting task force. And I know that while the legislation hasn't been signed yet, folks are getting ready. And I really appreciated Commissioner Williams' questions about kind of specific questions and ways to determine. And if I could respectfully suggest that I also really appreciated the conversation about competency and representatives' understanding of Voting Rights Act issues and community of interest issues, which are related but distinct. And I would just add to that, those good ideas, the suggestion that folks are also considered for their understanding about the importance of public input into the map making process to really make sure that the substance of the maps that move forward are reflective of communities of interest. And so again, I thank you. I also just want to acknowledge and appreciate and lift up that the good work that you all have done as a commission in terms of establishing credibility and relevancy and impact, I think made you a logical go-to as a partner in moving forward, meaningful redistricting reform in terms of implementation. And so kudos both to the commission and to staff for doing such stand-up work. So thank you.
Thank you, ma'am. Walker?
All right, let's go to Mr. Cliff Rees. Mr. Rees, I've asked you to unmute yourself and start your video. Here you go.
Thank you very much, Walker. Mr. Chairman, members of the commission, my name is Cliff Rees, a retired public health attorney in Santa Fe. I know you've had a long day. Very briefly, I want to thank you for the advisory opinions that the commission staff have prepared and you've approved, particularly the 5 or so that have been on the subject of the procurement code. I think this is a much needed tool to be used by practitioners I know for those of us who have advocated for the creation of the commission for many years, we saw this as an important function of the commission. And I just wanted to express my appreciation for a job well done to see that that's been fulfilled. Thank you very much, Mr. Chairman.
Thank you, Mr. Reese.
All right. I do not see any other hands being raised. Sunny, do you see anyone? Well, I guess
No, and I don't see anyone else in the chat, although actually just now popping up somebody else's in the
I
chat.
messaged
Yeah,
everyone.
okay, great.
All right, well, Chair Lang, I would suggest that we go to the next agenda item, and if anyone raises their hand in the interim, I guess we could go back.
All right, well, the next one I can handle all by myself. Determination of the next meeting, I believe we're set for June 4th. Plan on packing a lunch for that trip, as they say. And just a heads up to everybody, particularly those members of the public who weren't here for, maybe they didn't hear it. We have moved the August meeting from the traditional first Friday to the second one, which is August 13th, to accommodate a couple of commissioners' needs. So the next meeting is June 4th, and we'll go to August 13th. Anybody else raise their hand, Walker?
I don't see anyone, Chair.
Okay, then I don't know that we need a motion, but I will declare the meeting adjourned.
Great.
Thanks, everybody.
Thank
Good to
you.
see everyone. Everybody be safe. Thank you.
Thank you. Bye-bye.